do it.
All right. Well, welcome everybody. I know we still have people joining us right now, and I'm sure we'll have folks continuing to join. We are going to record today's presentation, so if you've got a friend that is not on the line yet, they will have access to the presentation later. And before we get started too, just some housekeeping. You can ask questions in the Q&A, and Allie on our team is monitoring the Q&A. So hopefully we'll have some questions while we're going along. So today's program is, and Allie, if you could go back one slide for me, Reimbursement Support Essentials, Compliance Insights, and Practical Solutions. So I'm Mark Gardner. I'm managing attorney at Gardner Law. I'm joined by Amanda Johnston, my partner, and Kim Norton, who's president of JDL Access. You can go to the next slide. Thank you. So we'll start with some introductions. I'll introduce myself, then Amanda will introduce herself, then Kim, and Kim will get into an overview of reimbursement support and what that means. Amanda and I will then be the fun police, and we'll talk about all the laws and things that go along with providing reimbursement support to hopefully keep everyone safe. We will try and reserve some time at the end as well for question and answer. We just have 60 minutes today, so we'll keep things moving along. A little bit about Gardner Law. I think most of you know our firm. I see a lot of familiar names already as attendees. So we are a law firm that's focused on counseling FDA-regulated companies. Bodies of law that we advise clients are the Food, Drug, and Cosmetic Act, which regulates 20% of the U.S. economy. So we have a wide range of clients that manufacture medical devices, drugs, foods, cosmetics. Laboratories are now becoming more and more regulated by the FDA. We also counsel clients on the Anti-Kickback Statute, the False Claims Act, the Sunshine Act, which we'll call Sunshine Laws, or excuse me, compliance laws. And we also have a privacy practice as well as a litigation practice. We'll talk a little bit more about that later. And my background specifically, I've worked in the healthcare industry for 25 years. I teach at the University of Minnesota Law School, Mitchell Hamlin School on Carlson, and I worked in industry at EV3 Acceleration and MedTox. I'm also a co-founder of JDL Access. I'm very proud to say that. I am not a manager at JDL Access. I'm not on the board, et cetera. I'm a silent investor in that business, but I am very proud of the things JDL Access is doing. And with that, I'll hand it over to Amanda.
Yeah, thank you. Happy to be here today. Just quickly, my name's Amanda Johnston. I am a partner at Gardner Law. I specialize at the firm in advising medical device and pharmaceutical companies on FDA law and healthcare compliance. My background includes in-house roles in compliance and regulatory and legal at United Healthcare, Medtronic, Coloplast, and I also serve as an adjunct professor of drug and device law. So first, we're going to have Kim give an overview of reimbursement support, and then Mark and I will pick back up after Kim provides some overview information on that. So Kim, with that, I will pass it over to you for your introduction.
Great. Thank you, Amanda. Hi, everyone. So glad you could join us today. I'm Kim Norton. I'm the president of JDL Access. I've worked in medical device reimbursement and patient access most of my career, and have helped to establish coverage for many emerging technologies. And in my experience of doing that, both within industry and consulting, I've utilized or managed many patient access programs, and have found that they are really kind of the key to success of doing that. And so I've become a really strong advocate of patient access for establishing new technology. So, I'm honored to be part of JDL Access now in order to really help other companies do that. JDL Access was established to provide reimbursement support and patient access services, along with our founding strategic partners, which also include JD Lyman and A&R Consulting, for the medical technology industry. And so really, as payers continue to create barriers to emerging technologies, our mission is to continue to provide best-in-class support to patients for patient access and ultimately to help establish positive medical policies. You can go to the next slide. And I apologize, I'm losing my voice today, right on time. So let's start with what types of reimbursement support are important for new and emerging technologies. And there's really three different components of that. And most patient assistance companies will have, the variations of these three services. And so it really starts with establishing a reimbursement hotline if it's needed, to answer coding questions if codes are complex, to address maybe coverage issues if there are some challenges, and just answer general reimbursement questions for providers. Really, when we start to get into patient access, we're talking about pre-procedure qualification and authorization, and then appealing denials. And so where we always start with patient access is verifying benefits. And typically that includes looking at whether the patient still has an insurance policy, what that policy includes, what the deductibles are and the copays and all those types of things. So really just making sure that patient has access through their insurance to a procedure or a service. And then getting into prior authorization. And this is really where, I think we've seen a lot of providers being upset by how much payers are requiring prior authorization, typically to slow down, access to services. But for new technologies, prior authorization is actually a really key component of getting a new technology approved, and I'll talk about why in a minute. But a lot of times for new technologies, payers are saying prior authorization is not required or prior authorization is not allowed. And so a case management service, patient access company will be able to help with either pushing for prior authorization in that circumstance or asking for a pre-certification or a predetermination rather than a prior authorization. The key to doing that is to get a written denial, and I'll talk about why in a second. But once you have that written denial, then you can move toward appealing a denied prior authorization for an emerging technology and pushing out to external review so that we're putting some pressure on the payers. And I'll explain why all of that's important on the next slide. So why are these important? When a new technology is launched, post FDA approval or clearance, there's sort of this canyon between when something gets authorized for marketing and when it becomes a standard of care or when it's deemed to be medically necessary. And in that canyon, where there's no codes or no fee schedule or no medical policy, providers have a hard time with being able to fight for access to that technology. It's not typically something they do every day. The office is typically not familiar with prior authorizing something that doesn't necessarily have a coverage policy or doesn't have a code. And so support services really help in that canyon to get procedures pre-approved, which in turn builds confidence from the providers to be able to bill and know that they're likely to get paid for the technology or the service, which then increases the utilization, which then leads to establishing new CPT codes, for example, where utilization is really important, and to establishing positive medical policy. So it's really hard to launch a technology face that canyon and not have that kind of support to get to the other side where things are considered medically necessary. Next slide, please. And again, going back to what I said earlier, it's really prior authorization that's the key to this whole process. For emerging technologies with no or negative medical policies, you can't get to an appeal without a written denial of a prior authorization. So knowing that something's not covered and likely to get denied, what we do is push for a written denial of a prior authorization. You can do post service claims, but they're really not as impactful as a pre-service claim. So that prior auth is really where we have some power. Assuming we can get a written denial and push through the no prior authorizations allowed, that's where then we'll start the process of doing an internal payer review. Sometimes payers require 2 of those, but typically it's just 1. And then we can get the patient's case out to what's called external review. And this is where an independent review organization is required for a payer to send a case for a reviewer, typically a specialist in the field of whatever the procedure is, to look at the case in total, to look at the medical records, look at the technology, determine whether they think it's appropriate in this particular case, and potentially overturn the case. Whether or not that case gets overturned, it costs the payer money every time that happens because the independent reviewer is being paid for by the payer. And so if you can do enough of those and get enough external reviews for a new technology, then typically you're putting some financial pressure on the payer to start to look at it and to think about establishing medical policy. And that's really the key to getting out to positive medical policy. It takes time, it takes, utilization, it takes key opinion leaders. There's a whole formula for getting to positive coverage, but this part is really the key to that. Next slide, please.
I have a question for you, Kim. We've heard
Yeah.
a few companies, their clients, where the payer is just refusing, and I think you mentioned it, refusing to review a prior auth. Can you talk a little bit about why or what we're seeing there or what you guys are seeing with that?
Yeah, it's a great question. And I think it's becoming kind of I think they're starting to appreciate that if they don't allow a prior authorization, they know that we can't get to
Yeah.
external review. So they have figured out ways to block that. And I know that there's a lot of advocacy around this to make sure that that's not allowed.
Right.
But they're doing it on purpose so that we can't get to external review. And again, that's why if you have a solid case management program who know how to push through that, who can get a predetermination or a pre-certification around that, or even a courtesy review, typically we can get something in writing. And it's just, staying on the phone, being consistent, being persistent, and, calling back if you get the answer you don't want. So
Right.
that's something a provider's office just doesn't do every day. And that's why it's so important, but that's a great question.
Right. Okay. Thank you.
Thank you. Yeah. So importantly, because of, what Amanda just said, this is why we do this on behalf of the patient rather than the provider. The provider just doesn't do this every day. They don't have the patients, they don't have the staff, the resources, but also they don't know the new technology as well as the company might or the case management company might. So, really this is where a solid case management company will be able to help push through getting that approval. But most importantly, we do it because the patient has that unique right to an external review. I think most patients don't even know they have this right. So, we have to do it on behalf of the patient. I think a nice benefit of that is we don't have to sign a BAA with every single provider office as well, because we're representing the patient. We are the patient representative rather than the provider representative. Next slide, please. The timelines on this are really important, and this comes back to really kind of level setting expectations around how long this takes. Before the Affordable Care Act, there weren't really parameters around this, around timelines. So I remember having cases that were out to a year or a year and a half. I don't even know how those patients waited that long. But now, because of the Affordable Care Act, there are timelines around every step of this process. There's 3 days for urgent requests for prior auth. We call those expedited. 14 days for non-urgent requests, and that'll actually be 7 days starting in 2026. Internal appeals, 30 days for pre-service, 60 days for post-service, and then external appeals, 3 days and 45 days. So at least now we have some parameters, but clearly this is a time-consuming process as well. Next slide, please. So what are some lessons that I've learned along the way, having done many of these programs? I think, Mark and Amanda are going to talk a little bit more about guardrails, but certainly creating some parameters around the program that you establish, whether you do that internal to your company or externally. And I know Mark and Amanda are going to talk about the advantages and disadvantages of having an in-house reimbursement service versus an external service like JDL Access. But having those guardrails, I think, and making sure that everybody understands them is key. Are you going to allow every type of payer into your program? Are you going to limit federal payers? Those are the types of questions that typically we need to establish before we start a program. Is this only for experimental investigational? Will you stop the program when it becomes covered or medically necessary, et cetera? So I think just defining what those guardrails are is important, and I know they'll talk more about that today. Level setting expectations. This comes back to the timelines that I was just talking about. If the sales team understands how long this takes, and if the providers understand how long it takes, you'll be able to maintain confidence in the program once they start seeing the outcomes, which typically, can be very positive. But if folks get frustrated with, the length of time, then I think you start to lose that confidence. So it's just really important to level set around that. And then finally, just being patient. It takes a long time to turn a payer policy around. It takes a lot of effort. This is a key part of it, but it will absolutely contribute to that outcome in the long run. So I will stop there. I will turn this over to my colleagues, Mark and Amanda, and certainly look forward to addressing your questions. Thank you.
Thank you, Kim. That was excellent. So we're going to get a bit here into the legal aspects, like Kim said. What's the legal landscape? Amanda will talk a bit about program structure, in-house versus third-party hubs, because some companies choose to just do this in-house. They don't, everyone hires a hub externally to run these programs. We'll also talk about risk mitigation strategies, something that I think everyone's keen on hearing about, and best practices, and we will have some time for question and answer at the end. So I'll start it off, and then I will hand over to Amanda. Coincidentally, I had a call. The call I had previous to this was with a lawyer within a medical device company, and this slide is one that I didn't present, but I talked about. And this is an area where there are a lot of tripwires with reimbursement support. That's why it's important to work with someone like Kim, frankly, whoever if you're going to work with a third party or if you hire someone in-house to do this work, you want to make sure that they have a strong appreciation for the tripwires that exist. So again, JDL Access is mindful of these types of risks that do exist with Kim at the helm, someone who's industry veteran. So the 4 big areas: privacy, right? You're dealing with a lot of patient information throughout. There's a lot of trust with the patient. As Kim talked about, seeking the authorization from the patient to have access to their data. That's a very intimate relationship with the patient. Failure to follow the rules can result in exposure under HIPAA, under the Federal Trade Commission Act. And now there's about 25 state laws. About half the states in the country have privacy laws as well. Someone you can keep up with is Paul Rothermel on our team. He's going to be putting out a news alert on potential federal legislation where we'll have a federal privacy law eventually. But for now, we have what is really a kind of a patchwork quilt of different state laws along with the HIPAA law and Federal Trade Commission Act. There's also regulatory exposure in terms of FDA promotion. And what I mean by that is a reimbursement support hub, whether it's again in-house or externally, it can't help with off-label cases. That's a safeguard, one that Kim hinted at, what sort of guardrails are there. So whenever we're working with clients to set up these programs, we say do not support off-label cases. So if a case comes through and it's unrelated to the approved FDA use for the product, that should not be supported in the reimbursement support process. Failure to do so, the FDA may take the position, or the DOJ, OIG, they may say, well, it looks like you are promoting off-label use via your reimbursement hub. There's also a lot of compliance risk, and that's going to be around the AKS, the False Claims Act, could even be Sunshine Act, but essentially providing something of value at no charge. Again, the perspective here is that these services and this assistance is being provided to patients. It's not to cover some overhead that the provider would otherwise pay for. This is all in the view of we are helping the patient here. So the company, all the folks on the phone, you have to think about whether you are doing this to try and get doctors to buy more products, or if you're trying to expand access of your products and your technology services, et cetera, to patients. And we'll talk a little bit about AdvaMed, but the government absolutely does tolerate this sort of support, obviously, or we wouldn't be talking about it today. The last circle on the graph there is litigation. And that's what we will hopefully avoid that, right? If a whistleblower leaves the company and they have their list of grievances and they go to the government, they try and become a whistleblower, that could turn into litigation if the government takes up that case. So that, they said, hey, they were promoting off-label through their hub. They had no privacy program. And, they kept these services going for 10 years, the whole time I was at the company. Even after coding, coverage, and payment was well established, they just kept doing this support, and it was an unlawful inducement. That's where the government might take up the case, and there would be litigation in that case. So the point with all these circles here, you've got a lot of risk. And so if you have one of these programs, you should be mindful of how you set it up. You should work with a vendor that knows what they're doing, that has policies and procedures to ward against the risks associated with each one of these circles, if you will. And you should also audit your program from time to time to make sure that there's no issues with it. We can go to the next slide. So these are the laws. I'm going to unpack them a little bit. I think, we've all worked in this industry for a long time, so we're familiar with the AKS, the FCA, HIPAA, et cetera, but I'm just going to go through them again fairly quickly to explain what these laws are. They're really intended to protect patients, consumers, taxpayers. So the anti-kickback statute, and I'll call that the AKS. It's just what it sounds like, anti-kickback. It means can't bribe people. So it's a felony to provide something of value in exchange for the purchase or prescription of products or services that are reimbursed by the federal government. And there's a lot of different federal healthcare programs. There's Medicare, Medicaid, CHIPS, Veterans Affairs, Indian Health Services, TRICARE. There's more than that even. So if a bribe is provided, hey, doctor, if you buy more of my product, I'll cut you in on my commission. That is unlawful. That is a kickback violation. And again, why does the government have this law? Why did Congress pass this law? To combat bribery, because no one wants to be given a product or have it implanted or be subject to a service because somebody is just making more money at the end of the day. It should be medically necessary. The penalties are very severe for kickbacks, up to $100,000 per kickback, plus 3 times the amount of the bribe. And the OIG is legally required to exclude convicted individuals or entities under the law. That's the exclusion authorities of the law. So if a company is convicted, they are kicked out of the healthcare system. And there's usually a time period associated with that. They can remediate their character potentially, but perhaps not, depending on the situation. It's really a death sentence is what it's considered for anyone that is excluded. And it does happen. So it's something the companies are very mindful of, and that's why you see settlements generally when there's AKS prosecutions. No one wants to go to the mat with the government on these cases because if they lose, they'll be kicked out of the healthcare system. According to the OIG, and this is from the compliance program guidance, reimbursement services, support services that are limited, and I'm going to kind of read this carefully because it's important. We submit advisory opinions requests to the OIG, and a lot of questions turn around this. We've actually submitted a few on reimbursement questions, and this sentence is one that we highlight. Reimbursement support services that are limited to a manufacturer's own product are not of independent value to the customer and do not implicate the AKS. So if the support services, if Kim and JDL Access went in and said, well, we're gonna provide support for all your products and services that you bill the government for, that would be inappropriate. But for a company to hire JDL Access for support around their product only and intended for the benefit of the patient, that in the OIG's perspective should not implicate the AKS. Of course, more analysis is required to make sure that everything is kosher and safeguards are deployed and policies and procedures to protect the company and patients are in place. Let's go to the next slide. And this is another area, and Amanda actually sat on the committee that reviewed this portion of the code last time it was reviewed. And I think Amanda, maybe you could just share a comment of being a part of that, and then I'll read a little bit about this. Was everybody on that committee in agreement with the AdvaMed code?
Yeah, it was actually very interesting. So I was on the rewrite committee, I think it was in 2020. And this section of the AdvaMed code got a lot of talk time. And essentially because there was a lack of agreement in terms of what guidance we should actually put in there, because there was disagreement over whether what's in the AdvaMed code actually aligns with the anti-kickback statute and the False Claims Act. So we ultimately did not make changes to it. But I just thought it was very interesting that with, the working group, the AdvaMed working group, who is, all the industry experts, lots of legal compliance people at medical device companies, that there was so much kind of uncertainty and not disagreement, but we couldn't come up with something that we all agreed on to actually make changes to this section. So keep an eye on, future iterations of the code, and we will see if anything changes here. But yeah, it was interesting. Yeah.
Yeah, I found that interesting when you shared that with me, because I was kind of waiting to see what would happen with this section, because a lot of changes were made to the code it's in 2020, and this one was not changed at all. And I'm, frankly, for industry and for patients, I was glad that it wasn't. I'll just run through it. And I actually highlighted a lot of text. Something I usually do not like to do is read text during presentations, but I think in this case, it's helpful. One thing, the AdvaMed code is not a law. There are states that have codified, if you will, the AdvaMed code or the pharma code, and they're quite similar. On this particular point, though, the AdvaMed code is unique. But you will see, like, Connecticut says companies need to adopt either pharma or the AdvaMed code, and they have to follow the compliance guidance from the OIG, the CPG, the 2003 CPG. Other states like Massachusetts and Nevada and Vermont, California, they're either as restrictive or more restricted than the AdvaMed code. So even though the AdvaMed code it's not law, it's written by a private organization, it is respected by regulatory authorities, federal and state. So, but that doesn't mean the government could just go ahead and disagree with the AdvaMed code. So I'll read a little bit, and this is in particular to reimbursement support. So the AdvaMed code, it says, in addition, I'm reading right from the guidance here. In addition, at the request of a healthcare professional to facilitate patient access to a company's medical technology and subject to appropriate privacy safeguards, the company may assist the patient by facilitating the preparation and submission of requests for coverage determinations, prior authorizations, pre-certifications, and appeals of denied claims relating to a company's own medical technology. So this is what we're using as air cover. It goes on to say, however, such assistance should not be provided as an unlawful inducement. So again, if the sales rep said, I'll provide you with this support, but you have to put a big order in, that would be inappropriate. But if the company says, you know what, we have a new technology, like Kim said, there's just coding coverage payment perhaps is not established, and we're going to provide this support for our particular device, and it's in the name of the patient getting access to it, that's okay, according to the AdvaMed code, which is right on the slide here. It goes on to say a company may not interfere with a healthcare professional's independent clinical decision-making or so that means that the company can't practice medicine, we all know that, or provide coverage, reimbursement, and health economic support as an unlawful inducement. That's kind of part and parcel to what we just discussed. And they give an example here, if you can bear with me for one more moment. For example, a company should not provide free services that eliminate an overhead or other expense that a healthcare professional would otherwise, of business prudence or necessity, have incurred as part of its business operations, if doing so would amount to an unlawful inducement. So again, we can't hire someone like you can't, I should say, you all on the phone, device companies, you can't like hire a staff member that just goes and they're now working in name the clinic system to be that reimbursement coder and support person. We're going to go back one slide, Allie. That would be inappropriate because you are basically now replacing a head count, for example. On the other hand, juxtapose that what JL Access is doing, or any firm that provides this outside support, or if you're providing it internally in-house, you're merely assisting with the patient access, you're facilitating just for that product, you're not going too far. Again, some analysis should be made in every circumstance to see how much support the company is indeed providing. The code goes on to state, further, a company should not suggest mechanisms for billing for services that are not medically necessary or engaging in fraudulent practices to achieve inappropriate payment. And that's, I think, pretty obvious what that means. We can go to the next slide. So again, just to put a bow on that last one, you can't provide, gin up codes or provide information that would inappropriately remunerate the providers for services or products that, for example, were not provided or that went beyond what was allowed, up coding, stretch coding, things like that. Okay, so that's the anti-kickback statute. If that law is violated, we automatically violate this next law, the False Claims Act. That's written into the law. The False Claims Act states that, when is this law violated? It's violated when false claims for reimbursement are submitted to the government. And the Congress has said, if you provide a bribe to someone and that results in us paying for something, that's a false claim. It's automatically a false claim. There's been other theories that have won in court where the government has said, you promoted your product off-label, but for your off-label promotion, we would have never paid for this claim. Therefore, you violated the False Claims Act. There's been theories where they've said, your privacy program is insufficient. And you attested when you submitted this claim that you followed all the rules, but you actually violated HIPAA. So now you violated under the implied certification theory, you violated the False Claims Act. So there's a lot of different ways the government can claim violations of the False Claims Act. They went after Lance Armstrong and when U.S. Postal Service did, because they were paying, the federal government was paying for that team to ride their bikes in Tour de France. And they said, hey, you were doping, so you violated the False Claims Act. And we're not talking about cycling law here today, but you can see where this law can be used in a lot of different ways. I'll just provide one other anecdote. This law goes back to the Civil War era and sometimes called the Lincoln Law, because during the Civil War, there was suppliers to the Union Army providing munitions and horses and uniforms and rifles and whatnot, and foods. And sometimes foods were rotten. The bullets didn't work. The guns didn't work. The horses were lame, whatever. So they said, if you violate this law, we're going to fine you for the violation. We're also going to penalize you 3 times the amount of the claim that you made. And there's also exclusionary authorities here. So if you violate this law, you can be kicked out of healthcare. So there's a lot of exposure with the False Claims Act. How this ties into reimbursement support, if we provide reimbursement support wrong, the government's going to say you caused those claims to come in, which we paid for and we shouldn't have. So now you're in trouble. We'll go to the next slide. Food, Drug, and Cosmetic Act, talked about this earlier. Obviously, it regulates how we manufacture and promote medical devices. And we talked about off-label promotion. And really the takeaway with this law, we don't support cases that are off-label that come through. If they come through, you should say that's an off-label case, can't support it, sorry. And that should be written into your program contract with your customers, you know, because you're going to want to memorialize certain things with your customers when you're providing this type of support to them. And you should say right there in black and white, we're not going to support cases that are inconsistent with the FDA approved labeling. We can go to the next slide. HIPAA, a law that's been around a long time. We all know it's intended to protect our health information. So the takeaway here, well, I'll go through a little bit of it. You have to make sure you're getting patient authorization to have access to their data, or you need to be a business associate. And so if you're doing this in-house, you need to check those boxes. If you're hiring someone like JDL Access or Priya or whomever it is, you need to make sure that you're checking those boxes. Either the patient is consenting to have their information sent to the hub, or the hub is a BA, a business associate, and they are entering a business associate arrangement with the provider. Failure to do so can result in HIPAA issues. And this applies for prior authorizations, for appeals, etc. So make sure you have a privacy program. I think, in 2024, we're going to 2025. Every client we have, I could think of, we have many has a privacy policy that deals with patient information at this point. If you don't have one, time to get one. That the laws and kind of regulatory risk associated with patient information and just privacy breaches and cybersecurity in general is only going to go up. So make sure you have a strong program. Let's go to the next slide. And I'm going to hand the baton over to you, Amanda.
Yeah, great. Thanks, Mark. That was good. So Mark provided an overview of, again, kind of all the tripwires that we mentioned. So all of the legal compliance considerations kind of that intersect in this reimbursement support program area. So we're going to talk a little bit now about different types of reimbursement support programs and kind of how to decide or what the different structure options are. So this is a little bit of an eye chart here, but just to think about, so once you've made the decision, you have a new therapy and you want to provide patient support, reimbursement support, you have a decision as to whether you want to build it in-house within your company, or if you want to contract with a third-party vendor like JDL Access. So we'll start with in-house, just kind of going through some of the considerations. So some of the advantages with developing an in-house program would be you have greater control over the processes, the workflows. Makes it a little bit easier to align with company policies because you have it kind of all in-house. Some of the disadvantages is you have to build a program in-house. So that means you have to hire staff, you have to train staff. If you're going to be signing business associate agreements, you have to set up be set up to be a business associate under HIPAA. It often involves, beefing up your privacy security program, beefing up your compliance program. So there is, quite a bit of time, money, and resources that are needed to develop the program in-house. It also requires discipline within the business because the reimbursement support program should really be walled off from the commercial aspects of the company. So making sure that the data that the reimbursement support team will be getting as part of the prior auth appeal processes, you can't just feed that into the commercial organization and, use it for marketing, for example. So it does require discipline, SOPs, policies in place, controls to make sure that the data is being accessed and used appropriately. In terms of scalability, having an in-house hub, again, there's a little bit more control over the processes and policies and inner workings, so it might be easier to scale. So if you're experiencing a lot of growth, it would be easier potentially to just add more staff. Of course, that makes the program larger and adds to cost and resources, but it might be faster and quicker to scale if you have it in-house. From a compliance perspective, I already mentioned it would require a very strong compliance program internally, and not only compliance, but also privacy and security. Customization, so you may have, again, kind of along the lines of greater control, there might be more opportunities to have flexibility or customize your offerings. Again, we'd want to be careful of the anti-kickback statute implications and make sure we're not stepping over the line and going beyond what, not taking on functions for the customers, but there may be some options for customization or flexibility. So then we'll look at third-party reimbursement hubs kind of in opposition, and I have the sun chasing me here, so I will try to escape. So if you do hire or engage a third-party hub, so like JDL Access, some of the pros are, they are the expert. That's what they do all day, every day. So you can really, hopefully rely on them to establish all of the policies, all of the procedures, the forms, the workflow. So that's, a big burden off of a company is being able to outsource that. So you don't have to develop internal systems and hire staff and create a program in-house. Some of the disadvantages, maybe you have less control over the operations. So, maybe not able to have direct access into how the process is being, completed. There could potentially be higher costs. Again, the cost is going to be dependent on the volume of claims and just what the program looks like, but potentially higher. But again, higher versus, creating your own program in-house, that cost consideration would be something you'd have to explore to see what it would be for your company. Disadvantage is you're also depending on a vendor to be compliant. So there are some safeguards that we'll talk about soon about how we can mitigate risk in that respect. But since you are kind of outsourcing, you're really relying on them to make sure that they are following the applicable laws and not creating risk for the company. Scalability. So often smaller companies will look to a third party just to get it up and running. It's quicker typically to implement than trying to do it all in-house. So we often see that being an option for companies that are small, have a unique novel device and want to get a patient reimbursement support program up and running quickly. Compliance. So again, the company is depending on the vendor for a lot of the compliance aspects, but there also needs to be some oversight from the device company. So just having that oversight, making sure that your contract with the vendor is structured appropriately to protect the company. With a third-party hub, you may have less flexibility in terms of, they may offer certain standard packages, whether it's benefit verification, prior auth, appeal, that kind of a thing. So you might not have as much flexibility if they have kind of packages that you can pick from. So at a high level, just key considerations. An in-house, if you're choosing to do it in-house, it's typically a high initial investment. But if you're looking for, if you see kind of a lot of growth, quick growth in your future, it might be more scalable to have it in-house. But again, weighing the pros and cons in terms of having it in-house, paying that upfront investment. And then on the other hand, if you're going to use a third-party hub, it's pretty quick. You can get it up and running. You don't have to worry about creating a program in-house and hiring and training people. And kind of all that is outsourced. So you don't have to develop the expertise internally. So that's often a really big benefit for companies. All right. So
I'll just
ultimately the choice, yeah, I was just going to say, ultimately the choice, it depends on the organization, the resources, your appetite for risk. There's pros and cons for each. So there's not kind of a right or wrong. And sometimes we'll even see companies switch back and forth. They'll start with a vendor and then they will decide to move it in-house. So sorry, Mark, go ahead.
No, that's a great point. Like you said, we've seen them go back and forth. When you're going through this analysis, ask your third party vendor about compliance, for example, about standardized offerings, how adaptable they are. Of course, today's program is we have Kim join us, and we have a very high opinion of JL Access. But you should be thinking about this regardless of who you utilize. And not all of the vendors out there are created equally. I mean, we, as recently as this week, Amanda and I, this morning, we're helping a client evaluate a vendor. So there's JL Access is focused, for example, on MedTech. This one that we're working with happens to be a pharma vendor. So there's different types of companies out there, but you really want to make sure that they're doing things right because they're working for you. And so make sure whoever you're hiring knows what they're doing.
Yep, exactly. So it flows well into the risk mitigation slide. So I guess, regardless of what approach or structure the company decides to take, some of the risk mitigation steps will differ. So like what you just said, Mark, if you are going to use a third party, make sure that you're doing your, due diligence in terms of vetting. So we routinely audit these third-party hubs. They're a little different than kind of an in-house compliance audit, but there are some questions kind of along the lines of the laws that we talked about that we would recommend kind of exploring and probing into with those hubs. Making sure that your contract is, has the appropriate terms in it to protect the company. Kind of you should be doing this anyway, but conducting risk assessments of just this landscape and if there's anything changing year over year. So if we start to see, some enforcement activity or, even changes in payer policies that might impact the risk of these programs. So it's good to always just keep that, or make sure that you're including your reimbursement support program within your overall risk assessment framework. There's a lot of good technology out there for secure information sharing. So if you are going to do it in-house, making sure that you're using the right tools, there's encryption, and then there's, if you are transferring patient health information back and forth, you'll want to make sure that you're using something secure that would comply with the HIPAA requirements. And if you're working with a vendor, making sure that if there's information flowing, between the vendor and the provider, or the vendor and the patient, that they are using, that would be another question that you'd want to ask, is kind of how are they doing that information sharing? And just like any other, program, making sure that you're, monitoring and periodically auditing the program. So again, we've done compliance audits from the device company side and also the reimbursement hub side. And just the final bullet here on this slide is just making sure, again, having a lawyer, getting legal counsel, just it's helpful to understand if there's any changes in the landscape. So are there enforcement trends? Again, anything that would be relevant that you'd want to incorporate into your risk assessment to determine whether changes to the program are needed. So just staying abreast of, current enforcement trends. Are there new laws coming down the pike? Is there, a lot of change in policy from a payer perspective that could impact the risk profile? Just something to keep tabs on, and legal counsel's a good resource for that.
I'll mention there too, Amanda, another good resource. Just keep tabs on what the OIG is doing in terms of their advisory opinion issuance. We've worked on a few of those with the OIG, and they were related to reimbursement. Just making sure that you're kind of checking the direction, if you will, of enforcement, posturing, and priorities. Mary Reardon is pretty accessible individual that we've talked to. She's at the OIG head official there, and I've asked her point blank at programs in DC when we've seen her is anything changing with your enforcement posture around the reimbursement support? And her answer has consistently been no, as long as it's not tantamount to unlawful inducement. And so we are, keeping paying attention to that. You can pay attention to our firm, but there's a lot of great resources out there just to keep yourself up to date on different, changes in how the government may be thinking about reimbursement support.
Amanda, when you're doing an audit, what are the types of things that you're looking for or looking at to assess all those issues?
Yeah, no, that's a good question. And it's going to vary based on whether it's in-house or third-party hub. But really the primary focus is the privacy compliance and kind of what their privacy program looks like. Do they have policies and procedures in place to address some of the high risk or key risk areas that often we use? Actually, the OIG has a compliance program guidance on billing entities. So we borrow some of the content from that. But really, we're looking to see, do they have their privacy program set up? Oftentimes we won't see a robust full compliance program like we would at a device company, but there are some aspects of that we would expect to see. Maybe having a compliance officer or having, a disciplinary process, that kind of a thing. So it does vary, but those are kind of the key areas, really focusing on privacy, because that's kind of the main source or the main outsourcing function that would be done there. But also, once the customer, and I think, Kim, you had mentioned having the device company setting the guardrails. So once you set those guardrails, then auditing the hub against that process. So just
Good
making
point.
sure that
Yeah.
they're actually staying within the guardrails of what the company had established.
Okay,
I'll
thanks.
just add to that because Amanda and I have together and with other teammates audited a lot of these programs. We'll sit with the folks and interview them. What do you do in your job? What forms are you using? Let's review those. What sort of interactions are you having with the patient? There's sometimes like bonuses that will be paid for. Or we've seen programs set up where if you get a bonus if the person gets approved and things like that, where that would be something we'd say no. Just be paying for the services, it's not a bounty for getting something approved. So there's a lot of AKS related aspects we look at, and then just how far folks are going with the submissions. I've seen some really interesting cases. There's case law on point where reps will be filling out forms on behalf of patients and just blatant, lying in the form. So getting into the process of how things work is important. And candidly, probably we've seen a lot of interesting things inside of companies in terms of how these programs operate. And it's sort of like you have to keep a straight face sometimes when you're hearing what some of the staff are actually doing on behalf of the patients, because there are situations to go beyond the pale where you're like, okay, you shouldn't be giving rides to the patients to the clinics and filling out the forms for them and just a litany of different things that can come up. So it's a good thing to just touch base with or another way of saying is to audit these periodically, just to make sure, like, if you're a general counsel within a company, that what's going on in your reimbursement support program, so that you're not caught off guard if you find out you've gotten a CID and you're like, oh, I wonder why. And it turns out there's things going on that you just had no idea about.
So important.
I know we're coming up. I got about 5 minutes left.
Yeah, yep. And I'll wrap this up pretty quick. This is, kind of, again, just putting a bow on things. So best practices, making sure that you're aligning the program with the OIG guidance. So that is the AKS topic that Mark explained, avoiding unlawful inducements, being careful, like Mark was just saying, to not take on customer functions. So, we're not becoming an admin in their office. And then also, keeping this reimbursement support separate from sales and marketing. As a best practice, the customer or the provider should be submitting those claims or prior auths to payers. Don't use the program to promote off-label or unapproved uses. We talked about that already. Really avoid having to log into the customer EMR and portals. That's just, you know, a safeguard or a best practice to kind of minimize the amount of information that is being accessed. HIPAA compliance really is kind of an overarching topic here. So either having a HIPAA compliant patient authorization form signed by the patient, and then declining the BAA, so not signing a business associate agreement and explaining why it's not necessary. So that's kind of the one option. Or the second option would be entering into a business associate agreement. And I have the caveat there that BAAs, I feel like that term and the document gets kind of flown around quite a bit, but really it can carry risk if you sign a BAA and you aren't actually set up to operate as a business associate. So that is a defined term under HIPAA. There are specific policies, procedures, and systems that you have to have in place to actually be a BA. So just kind of another reminder to be cautious of signing those unless you truly are set up to be a business associate. Again, having discipline internally if you are, I guess, internally or externally, but that program data, the patient data specifically, it is very limited. It is shared with very limited scope in terms of how it can be used or shared. So just having discipline and policies and procedures around that. Making sure that you're reviewing you have that copy review process, ad promo review process, any materials that discuss the reimbursement program, how it's framed, how we want the field and the other staff to talk about it, having that all kind of approved in writing in advance so that we're not going off script and potentially creating risk if it's being described as something that we're not intending it to be. Having SOPs in place to define the program scope, processes, really having those guardrails that you define, having those in writing and sharing those with the hub so that you have alignment in terms of kind of what you can and can't support. As with everything, auditing, monitoring, evaluating the effectiveness of the program. So it's important to actually keep track of, are you making progress? Are you, and as Kim said, it's a long process, but there are probably some metrics that you can evaluate and kind of monitor to see if what you're doing is working. So it's important to, have something like that in place so that you can actually see if if you are, if there's an improvement in coverage, to know whether the program is actually helping. So again, tracking and documenting that progress. And then really from a best practice perspective, because kind of the underlying desire or need for this, as Kim talked about, is really to drive policy or coverage for new kind of novel technologies where the reimbursement landscape may be challenging. Really the best practice is to have these types of programs in place only until, once you get great coverage and reimbursement, then you probably don't need it anymore. And maybe it's simple enough such that the providers can actually just do it on their own, because after a period of time, hopefully the goal is that it won't be such a challenge for every claim, and that payers will eventually get positive coverage policies, and then you won't have to provide this type of support. So I think that's everything we have from a content perspective. And I don't know if there are questions online that we want to take. I know we have a couple minutes here.
I don't think we have any right now. If anyone has a question, they can put it in the Q&A. And if not,
I have a quick question.
Yeah, please.
Quick question. Oh, no, Frank does. Go ahead.
Okay.
I think you'll have to enter it into the Q&A.
I see one. It says, what are some complexities to consider if you're a DME company with a contracted supplier to distribute your device, adding another partner to the equation?
Oh, I see. So they're a billing company themselves, but then potentially using a third party to do the authorization.
You want to take that one, Kim?
No.
Or Amanda?
And I mean, I've seen that set up before. If that truly is necessary to have kind of a third party be helping with the benefit verification, prior auth appeal type stuff, but typically the DME would handle it as they would be responsible for, the billing. So I guess I think it would probably depend on the circumstances, but I don't see from a compliance risk perspective, as long as everything's kind of on the up and up and we're not, there's no False Claims Act, there's no AKS issues, they should kind of be from covered entity to covered entity. That's kind of just my initial thought. I don't know, Kim, if you have anything else.
I don't see a problem with it at all. I think it would be just a matter of coordinating, the communication would have to be a little stronger there, but I think it's feasible.
Yeah, and I did see a hand up, but I'm texting that individual to see if they want to ask me their question, because they might not. Everyone's muted here. Let's see if we. See if I can unmute this individual if he's feeling brave. Actually, I don't. Let's see.
I don't think we can. Yeah.
Yeah, I think that person.
I think everyone's muted.
Okay, you know who you are. You could try out there if you want. Unmuted your mic, but it appears like it's muted.
Yeah, I don't think it'll let. I think it's set.
Oh, here it is. Okay, yeah, he just texted me and said he's muted. So I think we're at time, so we will run. And that if you have any questions, you feel free to follow up with Amanda or I or Kim. We'd be happy to chat more about this subject, which we find very interesting. And
yes,
it's one of many that we like to talk about. So feel free to reach out to us, and we'll be happy to talk with you more. And thanks, everyone. Thank you, Kim and Amanda. Great job today, and Alex.
Thank you.
Yeah, thank you all.